Good afternoon and welcome to today's training, Minor Consent Confidentiality and Mandatory Child Abuse Reporting for Title X Providers in Nevada, presented by, Rebecca Gudeman of the National Center for Youth Law. I just want to make an announcement that funding for this training is supported by MVPCA's Title X program under the OPA Office of Population Affairs grant. My name is Alicia Torres, and I am the Deputy Director of Reproductive Health Care for the Nevada Primary Care Association. NVPCA staff provides training and technical assistance, advocating for policy change on the local, state, and federal levels, and creating economies of scale through program management to Nevada federally qualified health centers. The FQHCs offer exceptional medical, family planning, dental, behavioral health care services to all Nevadans. On this slide here, you'll see 3 upcoming trainings, 2 in April, 1 in May. We have Towards a Trauma-Informed Resilience-Oriented Culture of Care training, Supporting Sexual and Reproductive Health Care Needs of Youth with Disabilities, and Healthcare Transitions for Youth with Disabilities. We will send these slides out. If you would like to register, just click on the blue hyperlink. Okay. Before we start today's training, I'd like to just go over a couple of housekeeping logistic items. If you have questions during the presentation, please feel free to put them in the chat box. Also, as you're logging in today and before we get started, if you can put your first name and last name and organization in the chat box. It's nice to see who from the community is here today. Excuse me, I am tongue-tied today. All right, and then in order to just reduce any background noise, we ask that you do put yourself on mute unless you do have a question. We will have some time for Q&A at the end, but again, as mentioned, feel free to put your questions in the chat box. We will be monitoring the chat box. And I think that's, and if you need to unmute or mute or unmute, there is the microphone icon there on the left side of your screen. All right, and I will let Rebecca Gudeman take over. Thank you, Rebecca.
Thank you so much. It's great to be with you all. My pleasure. I'm going to just go ahead and pop up my slides for us today. And then we'll get rocking and rolling. So yeah, welcome. It's great to be with you all. And I'm going to try to go through things relatively quickly. If you have questions pop up in the middle, please go ahead and put them in the chat. I may not stop to address them in the middle of the presentation, but then we'll have them and we'll make sure that we hit them at the end. Just want to make sure you don't forget as we sort of roll through things. Okay, and there we go. All right, so my objectives today, we're really hoping that by the end of this training, you'll have the knowledge and skills you need to understand what's reportable as child abuse and neglect and how to respond. And specifically, we're hoping that by the end of the training, you'll be able to summarize how consent and confidentiality works in Title X funded service provision. You'll be at least one risk factor or indicator of child abuse or neglect. You'll be able to explain mandatory child abuse reporting process, the sort of the who, what, when, and how, and describe at least 2 trauma-informed best practices that support clients. Because I'm a lawyer, we always do this kind of stuff. We got to do our caveats. I want to first say that the contents of this training come from 2 different sources. The first is a guide that's called Minor Consent Confidentiality and Child Abuse Reporting for Title X family planning providers in Nevada. We're on our 4th edition of this guide, and it will be shared with everyone as part of this presentation. And I'm also relying on a guide called the Trauma-Informed Mandatory Child Abuse Reporting in a Family Planning Setting Guide that's available through the Reproductive Health National Training Center that was co-authored by me and this amazing family practitioner expert, Erica Monasterio, who some of you may know because she also does quite a bit of training. Now I'm going to do all the legal stuff. It's important to say we only have an hour, and that means by necessity, we're just providing a summary of information. And it is information, not legal advice. So heads up that there may be times where you have fabulous questions, and all I can say is great question. You need to bring that to your own legal counsel because the presentation can't ever substitute for advice. And I also just want to lift up a couple things. This is about Title X settings, so it doesn't necessarily address confidentiality and reporting in other service settings, such as schools or domestic violence counseling centers, or with certain specialized populations, such as youth and child welfare, where there may be some slightly different consent rules and confidentiality rules. It doesn't address questions regarding receipt of Title X funding by tribal nations or questions related to tribal law. And it doesn't address other factors that Title X grantees and subrecipients should consider when thinking about confidentiality and reporting policies, such as documentation or risk management or ethics. And finally, I'll say this is presenting law. It's current as of today, but there's litigation pending. There's always new bills that can come up. So it's really important, if you're looking at this training, a recording of this training in the future, or looking at the guide in the future, to just double check with your own legal counsel to make sure that the contents are still relevant and accurate moving forward. All right, with all of that said, let's start with a review of Title X. So just grounding us, I know you all know this, Title X is a funding program introduced by Congress in 1970. Title X, it's called Title X because that's the section of the Public Health Service Act in which it's housed. It is the largest funding stream for family planning in the country. And the goal was to make family planning and related reproductive health care available to any individual who needs it, including adolescents. And indeed, Congress specifically called out adolescents as a priority population. Now, as I said, it is a funding stream, and that means that entities that accept Title X funding effectively enter a contract with a commitment to provide certain services and comply with certain rules in exchange for receipt of that funding. And among those rules are implementing legislation that requires Title X providers to comply with all state laws. Whoops, I don't know why it just did that. State laws related to reporting of child abuse. And it also requires the implementing rules also prescribe both the scope of services that must and may be provided, and then include regulations around delivery of care. So let's look at that a little bit. So as part of the rules, programs that accept Title X funding must provide certain services. They need to provide a broad range of FDA-approved family planning services, as well as reproductive services such as pregnancy testing and counseling, assistance to achieve pregnancy, and STI services. And while not every site in a larger project must provide all of those services, if a program does not provide, for example, a wide array of family planning, of FDA-approved family planning options, they must have a referral system in place. And programs are expected to provide most, if not all, acceptable and effective medically approved family planning. They also must provide these services in a way that's adolescent friendly and that's client-centered, culturally appropriate, inclusive, and trauma-informed. Goodness, I'm sorry. I don't know why my computer seems to be very sensitive. Sorry, where was I? Inclusive, trauma-informed, and that meet nationally recognized standards of care. Now, Title X funding can't be used to provide just any type of care, but the authorizing regulations do say that in addition to the services that programs must provide, programs may use the funding to provide other reproductive and related preventive care that's beneficial to reproductive health. And they give some examples in their handbook, saying, for example, Title X funding can be used to provide, for example, HIV prophylactic medication prep, or the HPV vaccine, or breast and cervical cancer screening, as well as mental health and intimate partner violence services. So if you have any questions about whether a certain service can be funded using Title X funding, that is a great question to bring to your legal counsel. Now, there also are Title X regulations that address consent and confidentiality. So the Title X regulations state that minors must be able to consent to their own Title X care, and that minors hold control over release of information generated during delivery of that Title X care service. There is no lower age limit for minor consent for Title X services. So again, that bucket of services we just talked about. And really the idea is that if a minor believes they may need this care, the Congress wanted to make sure every door to care and to a conversation with a trained professional was open for them. If they're very young, their disclosure may lead to a child abuse report or to other services, but it also could be that it's just an opportunity for education for someone who's simply confused about how things work. Title X agencies must encourage family participation to the extent practical. However, grantees cannot disclose Title X service information to parents or legal guardians without the patient, the minor's documented consent. Now, what happens if state law conflicts with this? Let's say state law would otherwise require parental consent for a particular service, but Title X says it needs to be minor's consent. Well, there's been a number of courts that have looked at this. How do we bring those federal regulations and state law together? And there's a consensus across several federal courts of appeals. So it's that court right below the U.S. Supreme Court. And they all agree that federal Title X minor consent and confidentiality regulations prevail over any conflicting state law. So that is the state of sort of the law right now, that Title X regulations prevail over any state law to the contrary. But it is important to keep checking with your own legal counsel about this, because there is litigation pending that, if it moves up and ultimately moves to the Supreme Court, could change that. But for now, this is still the state of the law. So just keep in conversation with your own lawyers and keep your eye out for any changes here. All right, so that was a real quick intro to minor consent and confidentiality. The guide that we mentioned up front does actually go into a lot more detail about what Nevada state law says about minor consent and confidentiality. So please take a look at that if you have specific questions or want to know sort of where we are in state law particularly for anyone who's providing services that may not be Title X funded and has questions about that. But what I'd like to do now is already move into child abuse and neglect reporting requirements under state law. And we're going to sort of bucket this by looking at the who, what, where, why of reporting. So as a reminder, again, Title X regulations and implementing legislation do require that healthcare providers comply with any applicable state mandated reporting law. Title X itself does not have special reporting requirements or alter state reporting obligations in any way, but it does require you to follow your state law. So this part of the presentation reviews our reporting requirements under state law. I do want to flag there may be other kinds of reporting requirements that apply in addition to child abuse reporting, such as reporting of communicable diseases. And so, make sure that you, in collaboration with your legal counsel, you understand sort of the full panoply of reporting requirements that may apply depending on the type of services that you are providing. Okay, so who must report? State law defines it by profession. And we've included just a few here. This is not the full list of who is a mandated reporter. You can find that in the guide and in this part of the state code 432B.220. But critically, it does include most healthcare providers. That first bullet, you'll see that it lists by profession, by license, and it lists a whole bunch of code sections sort of that you would get licensed under. But just so you know, this includes emergency medical services, physicians and physician assistants, audiologists, dentists, dental hygienists, chiropractic physicians, optometrists, physical therapists, pharmacists, marriage and family therapists, alcohol or drug abuse counselors, athletic trainers. So it's the wide panoply of folks who are licensed to provide medical care. It also includes any personnel of a medical facility that's licensed under Nevada statutes and who are engaged in the admission, examination, care, or treatment of persons, or an administrator or manager of such a facility. And any person who maintains, is employed by, or serves as a volunteer for an agency or service which advises persons regarding abuse or neglect of a child. So if you have any questions about whether you are a mandated reporter, take a look at the guide for the full list. The other thing to highlight is that even if someone is not a mandated reporter, they always can make a voluntary report of abuse. Nobody is prohibited from reporting abuse. All right, so when to report? So what state law says is that mandated reporters must report when the reporter in their professional or occupational capacity knows or has reasonable cause to believe that a child has been abused or neglected. So I've added some bolding to a couple words in there that I'd just like to lift up for a sec. So first, reporters must report when they know or have reasonable cause to suspect. So your job is not to investigate whether abuse or neglect has occurred. You're not required to confirm that it's occurred. Once you reach that threshold of reasonable cause to suspect, that's when you make the report. You don't need to go further than that. What is reasonable cause to suspect? State law defines that as to mean that if, in light of all the surrounding facts and circumstances which are known or reasonably should be known to you, a reasonable person would believe under those same facts and circumstances that an act or an event is occurring or has occurred that leads you to believe child abuse or neglect. So again, it's not about confirming, and it doesn't require that you even get this information directly from the young person who is the alleged victim. You just need to have that reasonable cause to believe. I also want to lift up that first part, professional or occupational capacity. So you are a mandated reporter in your professional or occupational capacity. Let's say you walk out of work and you run to the grocery store. And while you're there, you see an exchange between an adult and a child that leads you to know or reasonably believe that the child is being abused. While you certainly can choose to make a voluntary child abuse report, you are not mandated to report in that capacity, in that situation, because you are not learning these facts in your professional or occupational capacity. And just flagging that in this case, child means any person under 18 years of age. All right, so what is considered reportable that we're looking for, that we need to know or reasonably suspect? State law defines reportable abuse or neglect to mean one of three things: physical or mental injury of a non-accidental nature, sexual abuse or sexual exploitation, or the negligent treatment or maltreatment of a child caused or allowed by a person responsible for the welfare of the child under circumstances which indicate that the child's health or welfare is harmed or threatened with harm. Now, each of these is, the guide does go into these in full and provides definitions, but for purposes of today's training, I want to just focus on that second one, sexual abuse and exploitation. So what is sexual exploitation for reporting purposes? It means to solicit for or engage in prostitution, to view a pornographic film or literature, or to engage in either filming, photographing, or recording on videotape, or posing, modeling, depiction, or a live performance before an audience, which involves exhibition of a child's genitals or any sexual conduct with a child. Okay, so again, in the guide, we go through the definitions of each of these, but I'd like to look a little bit more at that first one, and prostitution. All right, so prostitution is defined as engaging in sexual conduct with another person in return for a fee, monetary consideration, or other thing of value. Now, in my office, we believe there's no such thing as a child prostitute. When someone under 18 is being prostituted, this is sex trafficking. And that is in fact true under Nevada law as well. A person is guilty of sex trafficking in Nevada if the person, quote unquote, induces, causes, recruits, harbors, transports, provides, obtains, or maintains a child to engage in prostitution, or enters any place within the state in which prostitution is practiced for the purposes of sexual conduct with a child. So any of that would be reportable, and it's considered trafficking of a child. Now, one of the things I wanted to highlight around prostitution is that term thing of value. There may be an exchange of cash money, but there also could be an exchange of, let's say, a roof over your head, or food, or an iPhone, or a computer. Some people may be engaging in activity that meets the definition of sex trafficking, of prostitution, without realizing it, because they think that prostitution requires an exchange of a fee or cash money. So it's really important to listen for the facts of what's happening and the context in which it's happening, rather than focusing just on the terminology or definitions people use. People may not want to label what's going on as trafficking or prostitution or whatever label it is. But if you hear that there has been an exchange of something of value for sex, then that meets the definition and would be reportable. And sexual conduct for this purpose means engaging in sexual intercourse, oral genital contact, or any touching of the sexual organs or other intimate parts of a person for the purpose of arousing or gratifying the sexual desire of either person. All right. So what is sexual abuse for reporting purposes? So state law defines it by reference to several criminal statutes. So here we have listed 1 through 7: incest, lewdness with a child, sadomasochistic abuse, sexual assault, statutory sexual seduction, open and lewd, gross lewdness, genital mutilation. All of those are actually terms of art in state statute. We have definitions for each of those, and we have their code section in the guide, so you can look at that and get a complete picture of what is considered sexual abuse for reporting purposes. For purposes of today's training, though, what we are going to do is just look at 2 of those in a little bit more depth. All right, so first, what is sexual assault for reporting purposes? This includes, but is not limited to, when a person subjects another person to sexual penetration or forces another person to make a sexual penetration on themselves or another, or on a beast against the will of the victim, or under conditions in which the perpetrator knows or should know that the victim is mentally or physically incapable of resisting or understanding the nature of his or her conduct. It also includes when a person commits a sexual penetration upon a child under the age of 14, or causes a child under the age of 14 to make a sexual penetration on themselves or another, or on a beast. And for this purpose, sexual penetration means cunnilingus, fellatio, or any intrusion, however slight, of any part of a person's body or any object inserted by a person into the genital or anal openings of the body of another. And that includes, according to the statute, sexual intercourse in its ordinary meaning. But it excludes anything that has to happen because for a medical purpose, for medical services being provided. Statutory sexual seduction means ordinary sexual intercourse, anal intercourse, or sexual penetration committed by a person 18 years of age or older with a person who is 14 or 15 and who is at least 4 years younger than the perpetrator. All right, so I know that this sometimes raises questions about when we need to report what otherwise would be considered consensual sexual activity. So we're going to walk through a series of questions that sort of look at what sexual activity ultimately needs to be reported. So first, what must be reported as child abuse? So as we saw previously, this includes incest, sadomasochistic abuse, which includes flagellation, torture, physical restraint. It includes genital mutilation of a female, and it includes sex trafficking, all of the things that we considered sexual exploitation. In addition to that, it includes any non-consensual sexual penetration, and it includes sexual penetration or contact based on ages in certain circumstances. So first, let's look at what non-consensual means. Okay, under state law, non-consensual means it was against the will of the victim, or it was under conditions in which the perpetrator knew or should have known that the victim was mentally or physically incapable of resisting or understanding the nature of his or her conduct. One of the common scenarios that we see in that second bullet is when folks have been using substances, alcohol or other substances, and are in a place where they are physically and mentally incapable of providing informed consent or knowing consent to engage in sexual activity. And that is one that sometimes surprises people when they start sharing stories and they share about sort of their state of mind and capacity. And so it can be one of those that's a little bit more difficult to talk about with clients, with patients. Is a report of sexual activity with a minor ever required based on age and activity alone? Yes. There are situations when you must report activities based on the age of the people involved, even when there is absolutely no other reasonable suspicion that this activity was either non-consensual or part of trafficking or exploitation or in any other way reportable. So you have no reason to be concerned, but based on ages and activity alone, you're going to report. And so those situations are when we're talking about sexual penetration with a person under age 14, unless their partner is less than 2 years older than them. Sexual penetration with someone who's 14 and their partner is 18 or older. Sexual penetration with someone who's 15 and a partner who's 19 or older. And then lewd and lascivious acts. So this is sort of the sexual activity outside of penetration between a person 18 or older and a person under age 16, or those activities with a person under age 14. So I know this is like a lot to look at. The handouts that you'll get as part of this training include a more sort of youth-friendly framing of ages, and the guide provides more detail about this. But this also raises sort of the flip question: what sexual activity with a minor does not require reporting? So when there's absolutely no reasonable suspicion that sexual activity was non-consensual or was part of incest or sadomasochistic abuse or trafficking or exploitation, and it's just, you're looking at a scenario where there was some sort of sexual activity and you've got a minor involved, it's not reportable. It's not considered reportable child abuse when it's a lewd act between two people who are both ages between 14 and 17, when it's sexual penetration or contact between two parties who are both 16 or older, or when it's sexual penetration between people who are both 15 to 18. All right, so let's say we now have raised reasonable suspicion of abuse. How do we report? So we sort of have 4 steps here. So first is that trigger. Information was shared that leads you to either know or reasonably suspect abuse or neglect. Once that mandate's been triggered, a reporter is supposed to report, quote unquote, as soon as reasonably practicable, but not later than 24 hours after that trigger, after you know or have a reasonable cause to believe that a child has been abused or neglected. And so that reasonably practical is important because it gives you space to complete whatever medical service you're providing and make sure that you're addressing the client's needs. The moment that they name their age and the activity, or the moment that they share that something was non-consensual, it doesn't mean you have to drop everything and turn to make a report. You can still focus on prioritizing the immediate needs of a client as necessary. But that report does need to go in no later than 24 hours after. How do you report? You can make a report by telephone, or given the surrounding facts and circumstances which are known or believed, you can use any other means of oral, written, or electronic communication that you believe is reliable and a swift means of communicating to the person receiving the report. If the report is made orally, the person receiving it, so not the mandated reporter, but the agency receiving it, must reduce that oral report to writing as soon as practicably possible. Now, who do you report to? You report to either child welfare or law enforcement. There are some certain guidelines about when you might report to one or the other. For example, the report goes to law enforcement if the suspected abuse involves acts or omissions by a person working for a public or private home, or for an institution where the child's receiving childcare. And if the abuse is at the hands of someone who works for a child welfare or law enforcement agency, you must make sure that you send that report to any agency other than the one that's alleged or that this person works for. So take a look at the guide for a little bit more direction on some of those special exceptions. What must a report include? There are 6 categories of information: the name, address, age, and sex of the child, information on their parents or other person responsible for their care, information about the nature and extent of the abuse and any of sort of the context, any evidence of previous known or suspected abuse, the name, address, and relationship of the person who's alleged to have abused or neglected the child, and any other information known to the person making the report which they believe is necessary. So that last category is important. Any other information that you think might be necessary. This is a good reminder that you're not required to become an investigator. You may not have all of the information that is in these 6 categories. You provide what you have and what's available at the time, and you let the department do any follow-up to fill in gaps. But that last bullet is also important because mandated reporting is an exception to confidentiality. So we may have Title X confidentiality regulations. We may have HIPAA and state law protecting, in a broad sense, the health information that has been created in this patient-provider interaction. It still is protected health information, but this mandated reporting law creates a carve-out that allows you to share what otherwise is protected health, maybe protected health information, if it's necessary to make a report. It doesn't mean that everything in the file suddenly becomes open and available. It does mean that if it's considered necessary to and relevant to the abuse report, then you are able to disclose it without violating confidentiality law. Now, if the welfare agency or if the law enforcement come back and they want to access all of your files, that's a really important time to reach out to legal counsel for guidance, because they don't necessarily have a right to see everything in the file, because it is still protected by HIPAA and by Title 10 and by other state confidentiality laws. So it's about figuring out what parts of it are still relevant and that they may still have a right to access. All right, what happens with reports? It really depends on the type of abuse, the age of the child, and the level of risk. In all cases, the child welfare agency is required, or the agency is required to evaluate reports no later than 3 days after their receipt to see if investigation is warranted. In some cases, the agency may immediately initiate an investigation. For example, if there's a report that indicates there's a really high risk of serious and immediate harm to a child. If the agency determines that an investigation is warranted, the agency is required to initiate that investigation no later than 3 days after their evaluation is completed. So 3 days to do that evaluation, and then 3 days to initiate an investigation if that evaluation says that an investigation is necessary. And child welfare and law enforcement are supposed to cooperate in any investigation of abuse. Now, one of the actually, I'm going to move to the next slide before I say what I was about to say. So one of the questions that often comes up is, will a parent or guardian know that I'm making a report, or must I inform them? So let's start actually with the last part of that question, must I inform them? So again, as I was saying before, most of you will be receiving this information in the context of a healthcare setting and providing healthcare. And so confidentiality laws, Title 10 and HIPAA and state law may apply and be sort of control release of information. Mandated reporting law is an exception that requires you to make certain disclosures to child welfare and to law enforcement. It doesn't say, and to parents. So unless parents otherwise have a right to access that information, you actually cannot tell parents or legal guardians that you've made that report without getting permission from whoever holds control of the records. And as we saw earlier, in scenarios where you're providing Title 10 funded services, Title 10 regulations say that the minor patient controls access to their own health information. So if you wanted to inform parents or legal guardians, you would need to get your minor patient's documented consent in order to make that disclosure. Now, sometimes your client may wonder whether their parent or guardian will find out. You can say, I'm not going to let them know, but it is important that your client understands that once that information goes to child welfare or law enforcement, they're not under the same confidentiality provisions that you are. So child welfare and law enforcement may, and in fact probably will, inform parents if this goes to investigation. Parents likely will find out. So if this is something where it looks like an investigation likely will occur, it may be something to let your client know that this is something that ultimately, even if it's not you, will ultimately get out to mom and dad. Okay, but let's go back to the first question here. These are some of the common questions that we get. Is a report still required if I don't have all the information necessary? So there may be a situation where your patient discloses something and they don't know the name of the perpetrator. Maybe they went to a party and they were sexually assaulted. They don't know the name of the person that was involved in it. They have very little details. But as soon as you know that there was non-consensual sexual penetration of a minor, that triggers your mandated duty to make a report. And so even though you may have very little of the information that we had listed here, you would still make a report with what you have and leave it to the agency doing the follow-up evaluation and investigation to dig a little bit further and try to get more information. But the fact that you don't have everything does not absolve you from mandated reporting. All right, how about liability? Can individuals be held liable for making reports or liable for not filing a report? Anyone who makes a report based on knowledge or reasonable cause to believe a child's been abused or neglected is considered immune from civil or criminal liability for making that report, as long as they made that report in good faith. And there is a presumption that reports are being made in good faith. There are situations where sometimes reporting is used as a weapon. It could be a family custody battle and there's reports going back and forth. That's the kind of scenario we're talking about when we talk about sort of bad faith or reports being made and not in good faith. On the flip side of that, if you fail to report, anyone who knowingly and willfully violates mandated reporting requirements could be held for a criminal charge. It's a misdemeanor charge for failing to make a report. Okay, I think that is it for that section. I want to just close by talking about trauma-informed reporting and sort of how do we do this process in a trauma-informed way. So remember, Title X requires providers to implement services in an inclusive, adolescent-friendly, and trauma-informed way, and that does mean incorporating reporting into those trauma-informed guidelines as well. Being victimized is frightening and disempowering, and disclosure of that takes great strength. But the reporting process can also feel quite disempowering. And so we really want to be mindful of that, even though we know that it may ultimately be for the good of our client or our patient. But we do want to do everything we can to ensure that the reporting process doesn't add to trauma and disempowerment. So just, this is from SAMHSA, a quick reminder: a program, organization, or system that is trauma-informed realizes the widespread impact of trauma and understands potential paths for recovery, recognizes the signs and symptoms of trauma in clients, families, staff, and others, and responds by fully integrating knowledge about trauma into policies, procedures, and practices, and seeks to actively resist re-traumatization. Guiding principles from the CDC to trauma-informed care include care and services that are provided with sensitivity and awareness around the client's possible trauma, creating a physically, psychologically, and emotionally safe space, allowing clients to feel a sense of power and control over the services they receive, and really trying to avoid being as transparent and honest as much as possible, so that things are predictable and people understand processes. It also means being mindful of cultural, historical, and gender issues and how folks coming from different contexts could perceive the same process in very different ways, and being mindful of that. So how do we bring this into reporting? So one of the first steps is to make sure that we always set the stage before any engagement. And what we mean by that is providing clear guidance about confidentiality and the limits of confidentiality. This helps with transparency, empowerment, and choice. Sometimes people believe that letting a patient know upfront what could lead to reporting will mean that they choose to hide, but that doesn't prove to be true. Oftentimes letting them know what it is that might lead to a report actually leads to more reporting. So what we really mean here is just phrases like, if you share something that suggests you may hurt yourself or others, or someone is hurting you, I might have to share information with other people in order to get you help. And then providing relevant, specific details about what that may mean given their age and the context that they're in. So safety first both in terms of having an immediate any immediate health needs met, but also checking for safety. By checking for safety, do they feel safe returning home or to school? Are there some immediate needs that we need to meet, especially if we're about to make a report? This may mean partnering with others to find support or at the youth's request, or asking for immediate response if we're really concerned about their safety going home. It may mean asking things like, if you're in crisis, who might you go to? But it also means addressing, as I was saying earlier, any urgent or immediate medical needs. If you're in the middle of providing healthcare services, we want to make sure those healthcare services are also being provided and any important needs are being met. When we're talking about the reporting obligation, it's important to frame the mandate to report in the context of getting help, rather than something that we have to do because the law tells us to. This is also about empowerment and about giving people more, oh my gosh, I'm blanking the word, bringing them more into the process. And then once reporting has to happen, providing them as much information and control as possible in the reporting process. So that might mean explaining what's likely to happen once a report goes in, who might know what, when, the timelines for things, reinforcing for them the power that it took for them and the bravery it took for them to disclose, and that the process that they're going through in reporting and what will happen is actually really shows signs of how strong they are. And to the extent that it makes sense, help inviting them into the reporting process with you to help fill out forms or to share information. I have often sat on the phone with a client in the same room. Sometimes that's not appropriate. It's up to you to decide, but it can really be empowering for them to be part of that conversation as well, depending on the age and what you're reporting. Okay, so I am going to end there just with a reminder that this was based on sort of the state of the law right now, and that we really encourage you to consult your own legal counsel before relying on this moving forward, because things could change. And I'm very happy to answer any questions now, although I will warn you that there may be some that I need to say that needs to go to your own legal counsel to the extent that it requires any advice or sort of practical application.
Thank you, Rebecca. Alrighty, and I'm looking through the chat. I don't see any other questions. There was a question about the handouts that were referenced, and they will be emailed out. Once you there's an evaluation immediately after you log out of this training session. So if you could please complete the evaluation, and then we will be emailing out the handouts and the updated guidebook mentioned. All right, any questions? Folks, you can put yourself off mute or raise your hand if you have any questions, or you can use the chat box.
Hi, my name is also Rebecca. I was looking at your slide where it's like 14-year-old and all these different caveats. You said that there'd be like kind of friendly handouts for like breaking that down a bit easier. A common question I guess I have with my patients is, seeing a 14 or 13-year-old that's having sexual intercourse with another kid their age. And I was trying to see where that fell in on here.
Yeah, so I just tried to put that same slide up again. So yeah, when you're talking about 14, 13, that's when it is important to really make sure that you're taking a look at this. So for example, sexual penetration, which is sexual intercourse with a person under age 14, is reportable unless there's that they're less than 2 years age difference between them.
So for that, it would be like if a 14-year-old had intercourse with a 12-year-old, then that would not be something that I would report.
So based on age an activity alone, you look at this, but the other thing to also really make sure you're looking at is this slide. So there, yeah, so, there may be a situation where even, okay, based on age alone, this isn't reportable, but you're always going to report if you have any suspicion that this could be considered non-consensual. So coerced, there was something, physical or mental capacity was compromised in a way. So don't, sometimes it's so hard to get the age thing straight in our head. We focus on that so much, we forget that other stuff. So I always start with that question of sort of, is this feel like this was truly consensual and I have absolutely no other concerns about it. And then once I've decided I have, this is not something that falls into any of those other categories, that's when you look at the ages.
Okay. Thank you for clarifying that. And then the last question on this slide is, so when it says sexual penetration, including intercourse, so the penetration can be, like we said, any other, it doesn't have to be vaginal or things like that.
Right. It could be an object. It could be other, anal or vaginal. Exactly. Okay. And all those definitions are in the guide. And, full credit to Alicia and Brandy and their team, because they're the ones that made the one-page sort of more youth-friendly translation of the legalese stuff that you see on this slide. But I think that will also be shared again. Is that right, Alicia?
Yes, the updated guidebook will be shared as well. So,
and the one pager that you all made that sort of says the stuff in a little bit more youth-friendly way.
Oh, yes, the minor consent document. Yes.
Yeah.
And then, I'm sorry, I'm monopolizing the questions. Someone can interrupt me if they have one. If we were talking about the consents for minors and the confidentiality, like, so we're not disclosing this to their parents, and that's only if the minor specifically requests to keep it confidential. Otherwise, let's say they come in, for a Title X visit, or come in, for birth control, or not disclosing a sexual assault, because that's a mandated reported event. But we disclose to the parents unless they specifically ask to keep confidential, or that's the baseline.
Yeah, that's a great question. The default is do not disclose. So you actually need to have documented consent from the minor in order to tell parents. So that means you have to go, someone may well, and this often happens, they may well come in with a parent who's, bringing them in and they want their parent involved, and that's wonderful. And we're encouraging that kind of family involvement, but you still need to make sure, even in those situations, that you're getting documented consent from the minor patient so that parent can be with them, or so that parent can be part of that conversation. So the default is do not disclose, and but it's really easy to just get that permission from your client, and then that lets your client know that you're really seeing them as the center of this, because so many young people are used to going to the pediatrician's office or whatever, and they just sort of tune out, and the conversation is between their parent and the provider, and it's a reminder to them that this is about them too. So it's wonderful that they want their parent there, but even you asking for that signature is reinforcing for them that this is about them, which is great training and sort of adolescent development as they're, learning to own their own healthcare.
Thank you so much.
Yeah, thank you for the questions. Good questions.
Okay. Well, if you do think of any questions after we hang up, I will put my email address in the chat, and you can send them over, and I can compile them and get them over to Rebecca. Well, thank you all for participating in this training. The training was in collaboration with the National Center for Youth Law and the Nevada Primary Care Association. And again, this is being recorded. It will be archived on mvpca.org. All right, great. Thank you all.
Thank you, everyone.
Thank you. That was great.